Okay, I'm also going to have this at the end of the presentation, so in case you did not get a chance to view that. So this webinar is being recorded on August 8th, 2024. The information being provided today is accurate as of the time of recording. Any future changes to the forms or laws may affect the nature of the advice given on this webinar. The webinar is also providing general legal guidance. It is not tailored to any specific transaction. If you need more detailed information or have questions about a particular transaction, I'd encourage you to reach out to your broker, closing attorney, and/or the SCR legal hotline. This webinar is also intended for active SCR members. So we have done 11 total forms changes that went live on August 1st. Those are available on our website, zipforms.loop DocuSign. And you will have the ability to look at those. If you tried to do a new transaction at this point, the forms we're about to go over are what you will see there. The old forms have gone away unless they were one from a previous transaction. 11 forms in total, but we're only going to go over 4 today. The 4 that we're going over today are the listing agreement, the buyer agency agreement, the compensation agreement, and then the sales agreement. The changes in the other 7 forms came from one of these 4. So if you can understand the changes in these 4 forms, you should be able to you wouldn't be surprised by any of the changes in the remaining 7 forms. If you're curious which forms those are, we have that full list available at screaltors.org/forms. So the first change you'll see is on the listing agreement, and this is actually a change that is going to be throughout all the SCR forms. The goal is to make the consumer aware of all their different options when it comes to payment of broker compensation. And so there is now going to be 3 amounts in which a compensation could be paid. You already have 2 of these. There is just a new one that is a 3rd option. So you can always be paid as a flat fee. You could get your compensation as a percentage of the gross sales price. Or this 3rd one, which allows for the compensation to be a percentage of another amount calculated by blank. What that means is you are still being paid a compensation in the form of a percentage, but the base of that percentage is not going to be the gross sales price of the home, but will be something else. Couple examples would be in a new construction scenario where the commission is only being paid on the base price of the home, or it's being paid on the base price of the home plus additions. This is not asking for a number in this blank and a number in this blank. That would simply be a flat fee. This is not asking who is actually going to peck it into the calculator. This is, are we going to have the base of the commission be something other than gross sales price? So this will be words in here and a number in the percentage blank there. Now, paragraph 2 is the amount of payment a listing brokerage receives for providing listing brokerage services to a seller. The amount of compensation that is agreed upon in paragraph 2 is the same whether or not the buyer is represented, unrepresented, represented by your brokerage, or represented by a different brokerage. The amount of the commit, because there's a blank that is filled in here that the seller says, in an effort for you to secure a contract on my home for this price, I'm going to pay you this amount. That amount is set unless and until the parties agree to amend it. That does require an amendment to the agreement or a pen and ink change to change it. Otherwise, that amount is locked in once the agreement is signed by both the seller and the listing brokerage firm. Now, paragraph 3 allows for with owner permission, for the listing broker to divide or share some of the amount that the seller has provided in paragraph 2 to other brokers that may be interested. So the first question that you will ask a seller is whether or not I'm even allowed to share compensation, making clear to them that if you do not, that is completely their right. There's no rule requiring them to offer to compensate another broker. And if that is not what they wish to do, they will simply notate that by initialing this blank right here. But of course, at that point, the total amount of compensation in paragraph 2 will that point go to the listing broker. Or in paragraph 3, the owner could say, I'm willing to allow you to share some of the compensation I have shared in paragraph 2 by initialing this blank here and authorizing you to offer the following amounts to buyer's agents or transaction brokers. Those numbers could be the same. Those numbers could be different. It is completely, it's fully negotiable by the parties. Anytime you see a blank with compensation, that means it is fully negotiable by the parties. The only recommendation I would make is if you have made the total compensation a flat fee here, then you should make sure it's a flat fee here. Or if it's a percentage of the purchase price here, percentage of the purchase price up here. You don't want to try to have your total payment be a flat fee and then be paying off a percentage of another amount. That's just going to be more complicated math than you need to make it. But make sure that the owner's aware that this is their option. They get to choose. Explain to them, the benefits of cooperating compensation. But if they choose that they do not wish to compensate another broker or allow you to compensate another broker, that is certainly their prerogative and right to do so. Number 4, so paragraph 3 is talking about commissions shared from listing brokers to buyer brokerage. It is not talking about commissions shared from seller to buyer's brokerage. Concessions is dealing with the seller's ability or willingness to share in the burden of the buyer's transaction cost. So concessions is talking about a seller paying a buyer, and that would be reflected on the sales contract in section 6A4. Concessions does not mean broker compensation. Concessions is assistance with buyer's transaction cost. So in section 4, the owner will have two choices. Either they will allow the broker to advertise their willingness to assist with those, or they don't allow it. Whether you select does or does not, that is still going to be a term in the SCR sales agreement that's going to have to be negotiated. If you put does, then make sure that you are following all your MLS guidance on where and how you can advise on concessions. And be aware that if you advertise a certain number or amount of concessions you're willing to pay, that you should expect that you are going to see that number in any offer that you receive. And you should be willing to back up whatever you put out into the public. Paragraph 14. Paragraph 14 gives the owner the ability to allow or not allow for you to make an offer of compensation on your brokerage website. You are not allowed to, and under no circumstances will make an offer of compensation on the MLS, reference an offer of compensation on the MLS, direct somebody to an offer of compensation on the MLS, or talk about the offer of compensation on the MLS or anything related to the MLS. But you can put it on your website, so long as there is not a link from the MLS to your website or a link to another website from the MLS that will eventually get to your brokerage website. But before you even put on the website, you need to have the owner's permission in order to do so. Be sure if you're in the new world that you're aware where you can and cannot offer to make offers of compensation, making sure that you will not be doing it in any forum where there can be a sharing of back and forth. There also is not going to be anything that can even in any way be tied back to the MLS. Paragraph 18 reinforces that the commissions between the listing brokerage and the buyer are not set by law and are not controlled by the MLS or any other organization or party that is not a party to this agreement. And paragraph 29 reinforces that the only way to change the numbers in paragraphs 2 or 3, that being the total amount of compensation for the listing, or the amount that is being shared with cooperating brokers, or even if something is being shared with cooperating brokers, the only way to change that is through an amendment to this agreement. So that is going to have to be done in writing and signed by both parties. If it is a verbal conversation, a text message, an email will not suffice. It actually needs to be a physical change to this agreement through a pen and ink change or an addendum. And those are the changes to the listing agreement that we have made and went effect on August the 1st. Next is the buyer agency agreement. The first change you will notice on this form is in paragraph 3, letter E. This has always been and has been in your code of ethics under standard practice 12.1. You are not allowed and should not tell a client that your services are free or at no cost unless you do not anticipate being paid and do not want to be paid. So if you have any number other than 0 in paragraph 5 of this agreement, you should not say your services are free. Your services are only free if you are not receiving any money and do not wish to receive any money for this transaction. Now, before you get to paragraph 5, make sure that any buyer has received a disclosure of brokerage relationship form, that they have been thoroughly explained the difference between being a customer and being a client, that they understand the services that can be provided to a customer, the services that can be provided to a client. Make sure that they are aware that you cannot, will not, and shall not take them into a home unless and until you have a written agreement, either to be a buyer agency agreement or a transaction brokerage agreement. The terms of the buyer agency agreement are in paragraphs 2 and paragraph 6. Paragraph 2 describes the scope of the agency agreement. The agency agreement can be for as broad or narrow of type of property as the buyer is interested in, and you are comfortable therefore advising them in. And paragraph 6 talks about the length of the agreement. If you sign an exclusive agreement, you and the buyer are working together for the properties described in paragraph 2 for the length of time in paragraph 6, and that is an exclusive agreement for both of you. So paragraph 5 is where we get into compensation. Just like with the listing agreement, all negotiations of compensation are fully negotiable. None of it is set by law. And whatever is in paragraph 5 is the maximum amount a buyer's broker can receive from a transaction unless and until them and the buyer sign an addendum to the agreement allowing them to take more. So paragraph 5 is the ceiling of what you can accept unless and until there's an amendment signed. A phone call, a text message, an email with you and the buyer is not sufficient. It needs to be a physical change to this agreement, initial and dated by both parties, or a signed addendum by both parties. So there are a number of options that are available for a buyer when deciding how they would like to pay you. You will show them all the available options, but as a brokerage, you can decide which options you provide. That is perfectly acceptable. You do not need to explain what, you need to show them all the options that are available, explain what options you have. Don't speak bad about any of the other options or any of the other brokerages. If it's not a match, then it's simply not a match. If you would like to, the first option is brokerage fee. Understanding again that this is a ceiling of the amount that you can accept of whatever is put in here. If there's a bonus offered in addition to the brokerage fee, that bonus can only be accepted if there is an addendum signed with the buyer allowing you to accept the bonus. So if you wish to sign an agreement and have brokerage fee be the amount of compensation, the agreement would be filled out this way. There would be a checkbox on brokerage fee. Then the buyer must initial only one of the following 3 options for amount of compensation. Will your compensation be a flat fee, a percentage of the purchase price, or a percentage of another amount calculated by blank? And they will initial whichever of these options they select, and they will put in a number in these 3 blanks, one of these 3 blanks that corresponds with where their initials are. The number must be exact. It cannot be a range. It has to be an exact number, so at any time, a buyer is fully aware of the amount of compensation that you will receive from this transaction and what the ceiling of the compensation you can receive from this transaction is. Once the amount of compensation has been determined, the buyer will then make one of the 3 initials down here of deciding on who will be responsible for making the payment of the compensation amount determined above. The first option is that the buyer has solely determined that they'll pay it. If you select option A, you are not seeking any cooperating compensation. You will not ask about cooperating compensation because your buyer has solely decided that they would wish to pay that amount themselves. Would recommend that the buyer do so in consultation with their lender and that you are aware with the lender that is a possibility. Option B is something that you currently have in your buyer agency agreement, which says that the buyer is responsible for the amount in the compensation field, but you will make every effort possible to get some cooperating compensation from the listing broker, or possibly even negotiate concessions in the sales contract as part of the buyer's overall closing costs. But if that is not able to be done, the buyer is ultimately responsible for any amount that was agreed upon under paragraph 5. And option C says that the buyer is not responsible for making this payment. It will either come from the listing brokerage or from a FSBO seller, but in no world will it come from the buyer. So that is simply brokerage fee. In addition, or as a standalone, you can have just one of these fees below, or you can have these in addition to the brokerage fee. If you wish to do a retainer fee or an admin fee, you will check the box under other, and then have the buyer initial next to retainer fee or admin fee and fully complete it. The retainer fee is an upfront fee that is paid upon the signing of the agreement, is non-refundable and paid directly to the brokerage firm. That fee is paid whether the buyer purchases a home with you or not. That fee is paid immediately and will not be returned. Now, you do have the ability to make that fee a credit against any other brokerage fee should a brokerage fee exist. If no brokerage fee exists because this is the only fee that you and the buyer have agreed to, then this will be a shall not be credited. If this is a fee in addition to the brokerage fee and there is no offset, then it will not be credited. But if this will serve as sort of a down payment on any sort of overall brokerage fee, and if there is a total brokerage fee, this will be a credit, then you will check the box that says credit. The main difference between retainer fee and an administrative fee is a retainer fee is due immediately upon the signing of the agreement, whereas the administrative fee can be paid a number of days afterwards, or it can be paid at closing. If you make the fee due at closing and there is no closing, there is no fee paid. You are able to have all three, a brokerage fee, a retainer fee, and an admin fee, all three in the same transaction. You can have just one of the three, or you can have two of the three. It is ultimately what you and the buyer determine is in both of your best interest for moving forward. And the only other change to the buyer agency agreement is in paragraph 20, which states that the only way that you can change the numbers in paragraph 5 is by a written amendment with the buyer. And that amendment has to be specific. You cannot just have a blanket addendum that allows you to take a higher amount or allows you to take any bonuses. The addendum needs to be specific to the bonus being offered, who's offering it, for what property, and what amount. There needs to be complete transparency on all these costs going with these agreements. So those are your changes on the buyer agency agreement. The next change is to the compensation agreement. The compensation agreement is the form that is used for seeking cooperating compensation with a listing brokerage or a FSBO seller. Compensation is not owed unless and until this form is signed. Otherwise, the payment of the buyer's brokerage payment will be figured out by the buyer agency agreement. Whether or not, even if the amount of cooperating compensation is advertised, the advertisement alone is not sufficient for making sure that the payment is received. This compensation agreement must be signed. It must be signed by the party making the payment and the party receiving the payment. A compensation agreement signed by only one party is not valid. There's no reason to have more than two parties sign this agreement. It would be the party who is paying and the party who's receiving. This agreement must be signed prior to the offer being submitted, but best practice would be to get this signed as soon as possible in the transaction, ideally before the showing of the home. I'll walk through briefly how to fill out this form to do it in the most efficient way possible. Then we will assume in this transaction that you are seeking cooperating compensation from another brokerage. So you will simply check the listing box, brokerage box, and you will write in the name of the listing brokerage name. This will not be the name of the seller. This will not be the name of the agent. This will be the name of the listing brokerage. Who are they going to agree to compensate? This would be the buyer's brokerage. We'll go in this line here. You will not have the buyer and the seller's name on these lines here, as there is a word or on the right-hand side. There's only one party making the payment. If this is cooperating compensation, as described in paragraph 3 of the listing agreement, then you would just have the listing brokerage name. The seller box would be checked and the seller name would be provided if this is a for sale by owner situation and there is no listing brokerage from whom to negotiate cooperating compensation. Next, you'll get to paragraph 2, where what is the reason for this compensation agreement? If it is a buyer's brokerage seeking cooperating compensation, then you will check the box that says buying, and you will write in here the buyer's name. Next, you will go in to paragraph 3. And in here, you will write in the property address. Next would be the terms of the agreement. This is going to be, when does this compensation agreement begin and when does it end? I would make sure that you give yourself plenty of time for it to end, as if you do not close before the end of that term, there will be no compensation owed to you. If you close before that, fine. If your buyer decides to not purchase the home, then the agreement will simply die on the vine. Then in paragraph 5, your buyer will decide, or you will decide with the listing brokerage what the amount of compensation is. Will it be a percentage, dollar amount, or percentage of another amount calculated by blank? That will be based on discussions that you would have with the listing broker, or will be based off of the buyer agency agreement that you have already signed with your buyer. So you will have that filled out in here or in here, depending if it was a percentage or a dollar amount, and have it payable at closing in both scenarios, unless there's a different scenario in which you and the parties otherwise agree, at which point you will put that in there. But the compensation needs to be filled out in this pre-printed portion up here. Now, in regards to the signature of this, we do not have guidance on who will sign it because there are many different combinations of who could sign it based on the number of checkboxes in paragraph 1. But for our scenario, where it is a listing brokerage and a buyer's brokerage, you will have 2 signatures. The first signature that should be on there is the buyer brokerage, and this will be the broker in charge, and that is the default, unless the broker in charge has dictated through office policy that one of their licensees can sign in their place. If that is a policy of a brokerage, that's completely fine. But if there is no policy, the default, like it is with any form in our library, any brokerage signing needs to be done by the broker in charge. The brokerage and the party seeking the payment should always be the first one who signs the agreement. Otherwise, you will have to sign it again after amendments. And then secondly would be signed by the listing brokerage. Again, the same thing. The default is the broker in charge, unless it is otherwise stated in office policy that a licensee can sign. If it is signed, if someone signs on behalf of the brokerage, that obligates the brokerage, whether that was done correctly or incorrectly. If there was an error, that will be sorted out internally. But this is how that agreement will be signed. Once this agreement is signed, this obligates the listing brokerage to pay the buyer's brokerage, whatever the amount is in here, should this buyer up here purchase the home and close by the date in paragraph 4. Having this information before going into a home would be very helpful for your buyer, so as they are aware if there's any remaining buyer compensation they will owe you, which would be added into their overall transaction cost depending on which method of payment and option of compensation they chose in their buyer agency agreement. Now, lastly, we're going to get into the sales contract. The first change you will see in the sales contract is in paragraph 6, which gets into transaction cost. This is a section that has caused some questions during my roadshow, so I'm going to try to go through this slowly, but in as much detail as I can. So there are a couple paragraphs that you need to make note of in paragraph 6. Number 1, section 1 talks about what are the buyer's transaction costs what are the costs to a buyer's in a transaction. This would be, what is the buyer going to be responsible for paying for at closing? If you were to look at a settlement statement, it would list out all the costs for a buyer, and those are detailed in here. Now, you'll notice that broker compensation is not the only cost that a buyer has in a transaction. They have a number of other costs, from lending to the closing attorney, to the title exam, to inspectors, to appraisers, to surveyors. So it would be important to know from a buyer as soon as practical, what do you anticipate in closing cost? Have them talk to their lender and get that number of closing costs that exist with or without you or any compensation owed to you. That is going to be a critical number for the parties to know when filling out this contract. Now, one of the buyer's transaction cost is what is labeled as contractually required real estate brokerage compensation. What that means is, what does the buyer still owe you after any compensation agreements have been agreed to? So if there is still a difference between the compensation agreement and what the buyer's agreement owes to you as a buyer's broker, that amount will be added to the closing compensation or closing transaction cost. If your buyer agreed to pay you solely through A, that would be added to buyer's transaction cost. If the buyer agreed to simply pay you an admin fee, and that admin fee is due at closing, that would be added here. But if the amount of compensation has been fully resolved through a compensation agreement, then the buyer does not owe any more compensation. So that amount will be zero, but the buyer will still have a number of other transaction costs, as you see in number 1. Now, number 2 lists out what the seller is responsible for paying at closing. Just like the buyer, they're going to have a column on the closing statement that will detail what their costs are for a transaction. Now, we will then look at paragraph 3, where there are some unique scenarios where there could be amounts that are added to the buyer's and the seller's transaction cost. If one of these may apply to you, you certainly want to make sure that you do the research, investigate this during the due diligence period. Now, paragraph 4 is concessions. This is what we've been speaking about with concessions. This is the ability of the seller to assist the buyer with any transaction costs they may have, one of which may or may not be broker compensation, but that is not the sole cost they have. There are other costs involved in a transaction besides broker compensation. So there are 4 options of what you can do in number 4. The first is the easiest one to explain and understand. The seller is under no obligation to assist buyer with the transaction cost, as the seller has their own transaction cost. They will need to factor into a decision of buying a home, whether or not that still makes the deal work, but the seller has the absolute right to say, I am not assisting with any transaction cost, at which point a 0 would be put in paragraph 4. The second option is the seller says, I will pay X amount of transaction cost, but I do not want any of that to go towards broker compensation. So they will put the amount in here, and the buyer and seller will need to initial this option down here. What that simply means is any of the amount that the buyer is willing to pay in transaction cost must go to the other items in paragraph 1 other than contractually required broker compensation. If that number is equal to or exceeds X, then the buyer will get the full amount of transaction cost that the seller was willing to pay. If the number is less than X, then the buyer will not receive that full amount, but they will receive whatever is covered. The third option is the seller says, I am willing to give you X in closing cost, and I don't care where it goes. At that point, they would put X here, and we would initial these 2 lines. This would simply allow the closing attorney to look at the buyer's overall closing cost, look at the amount the seller is willing to pay, and do a straight line cut. There would be no distinction made of what the costs are and what they aren't, because we are just skimming from the top. There's X amount of buyer's compensation or buyer's closing costs. Seller agrees to pay Y. We're just taking Y out. The fourth option is where it gets a little bit more complicated. This is when the seller says, I will pay you some closing cost, but I'm going to restrict how much of that could possibly go to broker compensation. At which point they will put a number less than X in number 4. They'll put in here. So we'll make this, where they could do, an example, I'll do it actually with numbers. Say they were willing to pay $5,000 in closing costs. They could say, yes, but I will not allow more than 500 of that to go towards broker compensation. Now, if there's more than $5,000 in buyer's closing costs that don't involve broker compensation, then the buyer will receive the full $5,000. If there's $5,000 in closing costs that don't involve broker compensation, the buyer will see the full $5,000. But if the buyer has less than $5,000 in closing costs that do not involve compensation, the buyer will receive all of that amount plus $500, so long as that does not put them over $5,000. But if that number is still less than $5,000, that is all the buyer will receive. There has been some confusion as to what I should be putting in here for the blanks. If there has already been a compensation agreement agreed to between the two brokerage firms, that is an agreement separate from the sales agreement, should not be referenced in the sales agreement, and should not be added in this section. When we are talking about broker compensation, we are simply discussing what is left for the buyer to pay after any offers of compensation. So in order to properly fill out this section, it would be important to know from a buyer and their lender, what are the amount of closing costs without the broker compensation included? What is the amount of what is left of the buyer's compensation to be paid based after any compensation agreement? That information could and should be known prior to ever going to look at a home. You would also want to know from a buyer and their lender, what is the maximum amount your lender will allow you to pay at closing in closing costs? Or what is the maximum amount you are physically able to pay in closing costs at closing? Once you know those three numbers, you can try to solve for concessions. Concessions, though, to make it abundantly clear, is not broker compensation. Concessions is all the items up here. Costs and closing costs are resulting from selected financing, prepaid recurring items, insurance, discount points, interest, non-recurring closing costs, title exam, VA, FHA, VA allowable costs, fees and expenses for closing it for buyer's attorney, cost of any inspector, appraiser, and surveyor. And yes, contractually required broker compensation, but it is not a one-to-one. So the seller can simply agree to not offer to help the buyer with any of their closing costs. The seller could offer to pay closing costs, but say it has to go everything but broker comp. The seller could say, I'll give you this amount in closing costs and I don't care where it goes. Or the seller can say, I'll give you this amount in closing costs, but only so much can go towards broker compensation. Having and knowing your numbers will make this much easier. Again, the math will be done on the closing attorney side, but talk to the buyer's lender, have the lender work with you on this if numbers are not your thing. The next change is in paragraph 14. A very simple change. If you are being paid by a home warranty company for filling out the paperwork, not from a referral, but for filling out the paperwork, all parties must be aware of that. That must be disclosed in paragraph 28 of this agreement or in an addendum. Paragraph 27 simply states that all the compensation that is being paid in this transaction is based on an agency agreement or a compensation agreement, that there is no outside agreement for compensation and everyone is aware of where the money is and can follow it. No one is going to be surprised by the amount in a broker compensation line on a settlement statement. And lastly, paragraph 28. Paragraph 28 is where we give direction that this is not a place for you to negotiate compensation between a party and a broker. Those discussions need to be done either with their client and their agency agreement, between the two brokerages and a compensation agreement, or between the buyer and seller as part of concessions in paragraph 6 of this agreement. The reason is you do not want to have a discussion about your compensation be in a transaction between a buyer and a seller. The only recommendation we would give for putting compensation in paragraph 28 is where you mentioned that money from the home warranty company we mentioned in section 14. So that is the change to the sales agreement. I did want to point to something I have down here at the bottom to kind of outline the 5 possible routes for payment of broker compensation. So the seller has the ability to pay their listing broker through the listing agreement. The seller has the ability to pay the buyer through concessions in paragraph 6. The buyer has the ability to pay their buyer's agent through the buyer's agreement. The listing broker has the ability to pay the buyer's broker through a compensation agreement in Form 120 that's done in compliance with Section 3 of the listing agreement. And you have the ability of a FSBO seller to pay a buyer's broker for cooperating compensation through Form 120. So we understand that there are going to be a number of questions you have from this. I hope that this was helpful and a little bit more of a detailed explanation of what each of these forms do and do not do. Again, if you have any questions, I would encourage you at this time, you can certainly start reaching out to the legal team. Again, please only email one of us at a time, or if you do not have a particular preference, or if you simply wish to have first available, then reach out to the legal hotline and have a ticket created. I will leave our contact information up there for a few moments. Certainly appreciate your time and attention this afternoon. And thank you all for attending and your time.